Mr. Chairman, yes, we have 2 or 3 points, and that's all. Needless to say, most of our comments will come in our post-hearing briefs. A lot of things to cover there, but tonight we will just cover 2 or 3 points. And the first point is the statement made by Germany that we have not answered question 10 on your list of questions, which I believe we did, or at least I did. So the answer is that the NEPVs of the Brookdorf plant have been expropriated. The NEPVs constitute an investment under the ECT by virtue of our 20% holding of Brookdorf. If you look in the definition of investment, it refers to assets, any assets owned or controlled directly or indirectly. And that's how we define it and why it is part of our investments which have been expropriated. So that's the answer to question 10. I hand over to Dr. Hupp, please.
Thank you. Mr. President, members of the Tribunal, we have only 2 points. 2 points which illustrate how respondent handles the
Professor
case.
Hupp, I thought you were addressing the second point, or are you going now?
Yes.
2.
Oh, he's become a professor now. Okay, you're
I
good
promote
at
everybody, so this as you
So he's dealing with the second and third points.
Yeah.
Second point, okay,
Yeah.
please proceed.
The second and the third point. Those 2 points illustrate how respondent handles the case and what you should bear in mind when you examine respondent's submission. The first one relates to the very interesting discussion about the Harsha factory case. Well, I enjoy legal history, but the Harsha factory case played in the last century, and this is a case running under the Energy Charter Treaty. The Energy Charter Treaty specifically says that both in cases of direct and indirect expropriations, the valuation date is ex ante, not ex post. What respondent tries to do is to have you ignore the Energy Charter Treaty. That's simply ridiculous. The third point relates to the facts. You will recall that my learned friend on the other side of the room, when she criticized Mr. Kaczmarek, spoke about the Brockdorf issue. That's on slide 177. And she says there, Mr. Kaczmarek's... Okay. You found it? Thank you. Now, she makes the certain contention that Mr. Kaczmarek's assumption that KBR, Brockdorf, will close in 2019 conflicts with the state of knowledge as at March 2011. Well, there are some documents on that slide. They are unfortunately in German, but I'm happy to translate that. What you see on that slide left is the Geschäftsbericht, the business report of Brockdorf for the year 2010. And the year 2010 included, of course, the lifetime extension. And then the report says, and you see this year 2031 circled, for KBR, out of these legal changes and amendments, there are additional electricity volumes of 146 terawatt hours and a calculated lifetime extension until the year 2031. So what respondent has done is criticizing Mr. Kaczmarek's actual estimate with the but-for estimate, the lifetime extension. And she's done that so quickly that my guess is none of the members of the tribunal might have noted that, and it's also in German. That is how respondent handles this case, member of the tribunal. We will deal with all other aspects which were raised in our post-hearing briefs. Thank you very much.
That concludes the rebuttal for the claimants. Dr. Conrad, rebuttal for the respondent.
30 seconds. was having the iPad issues of Professor Law. Let me just very briefly come back to Article 13, about which we had a very interesting and very enjoyable discussion. Article 13.1 of the Energy Charter Treaty is pretty clear. The compensation under 13.1 only relates to the compensation fixed at the time of the measure, not to a regulation which is arguably an expropriation but isn't, and where the proper method is determining the delta from an ex post point of view. And the applicable law and international law, which was seminally explained by the Horshov factory case, which again is often cited and rarely read, is still good law. The international law concept of that an expropriation in general international law was to be accompanied by compensation was in place at the time of Horshov. The PCIJ explained that in very detail, and indeed explained that that there's an exception in its present case, the Horshov factory case, because the treaty, as an exception to general international law, did not provide for compensation. And the Horshov factory case, as is right, applied the delta method, which is and applied an ex post valuation, as is perfectly proper. Thank you very much. No further comment.
That completes the rebuttal for the respondents. Sorry.
Absolutely. Thank you very much.
Thank you.
And I think I have only words of thanks to the ever-patient David, dealing with people speaking in at least 4 languages, as I've counted in this arbitration.
We come to that. First of all, we confirm the dates for the post-hearing submissions. That's March, May, first simultaneous filing, and then what is it, the 1st of May? For the 1st of May, the reply filing simultaneously. There are still dates to be set for the cost submissions. I suggest that the parties do that in agree on the dates in consultation amongst themselves, but not too long after those dates, because the tribunal is already, let's put it this way, not too happy with the long periods that the council take to prepare their post-hearing submissions. We are of the opinion that we should try to expedite the arbitration as much as we can and to come quickly with an award. Anyway, we will try to do it after your submissions. We'll come out with the award as soon as we can. So the date of the award is approximately June, July 2017. It would have been earlier if we had shorter periods of time for the submissions. Then my question is, are there any outstanding matters? Professor Hobert?
Not from the claimant side.
Respondent, any outstanding procedural administrative matter?
No, nothing from us.
Right, then we would like, as a tribunal, to thank first of all the secretary of the tribunal for all the wonderful work they have done, and also the assistant of the tribunal within the tasks described in the letter. We would like to thank ICSID and its entire team for making this logistical operation possible here. We would also like to thank David, the significant other who was there for earlier last week, to help him, but I'm much impressed by what he did alone this week. Above all, we would like to thank the council on both sides, but not only those who sit here in the front row, but also in the back row. I know what it means, all-nighters, when I was a young associate, and the paralegals. It's very much appreciated, very efficient done the work and the presentations. Thus we have made our work, which was considerable and still considerable, much easier. Of course, we would like to commend counsel on both sides very much for the highest quality of presentations for their case here. With that, I have one final question for the claimants. now the day is over for closing arguments. Could you still ask your client whether they could have this also, the video of the closing, on the ICSID website? Because I think that the viewers may now have an unsatisfied or uncompleted feeling that they have only seen the opening. A natural inclination is I would like to see the closing. Maybe you would like to consider yourself, first consult your client and may let us know later. But that is a wish for the tribunal. The tribunal is very much in favor, as you have noted by now, for transparency, also for investor-state arbitration, and would much appreciate it if you could also complete this transparency in this case by also having the closing statements available to the public on the ICSID website.
For the record, although I don't see that they're here, you might include the interpreters who did a
Yeah, exactly. Yeah, that's true.
thorough, good job.
Well, Mr. Chairman, I'm advised that the answer is yes from the client.
Right. Okay.
Having said that, we would also like from the claimant side to thank the tribunal very much for having worked very hard and being so attentive, so thank you very much.
I have something unusual, actually. I have a correction to the thank yous of the President. What you've just described a significant other of David,
Oh, yeah.
whom is not him. So
I know. It was a little bit.
I'm sure you know. But
No.
let me join everybody in thanking Lindsay for her efforts, and which included, which is very important for me, climate control, and obviously also Emily Hay and the entirety of the ICSID team for putting on this great effort, including the filming, which I know from having to organize hearings by videocon is not a trivial thing at all, and the interpreters and David, obviously, but also, of course, all three members of the tribunal for having borne with us for 2 weeks straight, and for not having lost patience with, small digits on spreadsheets.
Thank you so much. And I'm remiss indeed in not thanking the interpreters, but also the AV team upstairs and downstairs, for because there's also the streaming people are downstairs, for making it all available and making it transparent for those who wish to see it with the 4-hour delay. Right, then the tribunal, we can close now the hearing. I wish you all a very good trip back home, wherever your travels may bring you, and take some rest, if I may give you an advice. Thank you. Hearing closed.